Hey folks, Dale Davidson here. Glad you're joining us. They call me the VA guy. Thank you for being here. Hey, today we've got a treat for you today. We'll be talking about nexus. I know it's not really a treat, but hey, I'm just trying here. So anyway, we previously covered that there's basically 3 requirements that a veteran needs to satisfy to be entitled to disability compensation, or I call it compensation. Okay, there's a current disability, the injury occurred during service, and you got to connect all that. It's called nexus. Okay, so today we're going to be covering the 3rd and final requirement, which is demonstrating that there's a link, a nexus, a connection between your current disability, okay, that's the first requirement, remember, and your period of military service, okay? In other words, is your disability service connected? There's some kind of service connection that has been established, okay? The most common reason the VA claims are denied for compensation is the failure to prove a nexus between your current disability and something that occurred during your period of military service. So one of the keys to success in compensation claims involves the process of proving connection or nexus. Okay? So just know that in most cases you must prove service connection. Under the VA, there are basically 5 different legal theories or methods that we use to show that your disability is linked or connected or has a nexus to your service, okay? There's a direct contributory link between your current disability and something that happened during your military service. We call that a direct service connection, okay? And we're going to explore all of these later on, okay? Second one. Your current disability pre-existed your service, but somehow was aggravated during your service or became worse during your service. Of course, this is known as aggravation, okay? Now, the third one is your current disability is a condition that did not manifest itself during your service, didn't show up, didn't come about during your service, but somehow, some way it now has come about. Now that is called presumptive, and we've talked about presumptive service connection in other videos. Okay, now number 4, your current disability is caused or aggravated, worsened, okay, by your primary medical condition, and your primary medical condition is itself connected to your military service. That's called secondary service connection. For example, your right knee is injured during service, okay? And so because you're favoring your right knee, your left knee starts to hurt because of overuse. That would be like a secondary service connection, okay? Simple example. And the last one, which really isn't one of the main ways of establishing service connection, but we throw it in here anyway, is that your current condition is a consequence of an injury caused by the VA itself, okay? You were in the hospital, you were in some kind of rehab services, something happened to you and you were injured. This is like a medical malpractice claim. But that is the 5th one, but we're not going to address that 5th one. We're going to focus on those first 4. So first, the VA must consider whether you are entitled to compensation under each of those first 4 theories. What they're looking at is the reasonableness of what you have raised, okay, in the record. In what have you said in your stressor statement? What has the medical doctor said? All of those things, it's just not what you state, but they're going to look at each method to try and get you that service connected, okay? Second, okay, and I think by far the most important consideration in presenting compensation claims for most of the service connection theories is the evidence showing the link, the nexus, the connection to service must always be supported by medical evidence. So medical evidence is the key. Now, I've done some videos on that before. I did one on DBQs, don't file without this form. Go back and check that video out. Realize it's not the theory you use, but what you have raised in the facts, okay? But the medical evidence is the key. The VA they have a duty to assist you to meet this requirement by obtaining medical opinions whether the nexus exists. But guess what? Don't rely on the VA to help you. You do it on your own. Let us help you, whatever we need to do. Let's get the independent medical advice so that we can submit those to the VA. Now, you might think that you're saddled with a high standard of proof, saying, boy, I got to prove this service connection or I'm just totally out. I mean, I got to say, 99% sure that I'm service connected. No, that's not the case, okay? Here's some buzzwords that you need to be aware of. And we need to make your medical providers aware of them too. It is as least likely or not that your injury was caused by your service. It's more likely than not that your current disability resulted from your service. So it's not 99%, it's least likely as not. Okay, so it's not that high, but you got to have the medical evidence, and that's what we want our doctors to, when they're completing these DBQs or giving you an opinion letter, we're going to consult with them. You need to consult with them and give them, this is what you need to say. Direct service connection, okay, meaning that your current disability first began in service, or your injury or disease, whatever it was, occurred during service. So you went to the hospital, you were in the medical, whatever your rehab, whatever it was, you've got documentation, you've got medical evidence that is actually in the VA files as to your direct service connection. They know that you broke your leg in service or arm or whatever it was, because there's medical evidence. The problem we face is a lot of times you are injured, but we don't have direct medical evidence because you didn't go to get medical attention. For example, I had this one client who, he's a Bradley fighting vehicle, was blown out of the turret after his gunner drug some of those shells across part of the metal of the vehicle, and it blew him out of the turret. He was unconscious for several minutes, came to, dusted it off, and said since he had no physical injuries, no visible physical injuries, he was good to go. Take the rest of the day off, but you're good to go back to training the very next day. Nothing's in his medical records, but he remembers the event. So you can submit the VA's medical evidence, or you can get your doctor's medical evidence. Whatever it is, let's have some medical evidence that links your current disability to your particular disease, injury that occurred during service. This is where the DBQs come in handy. Don't file a claim for compensation without a DBQ. Compensation can also be paid for disability caused by the aggravation during the period of service. You had a pre-existing injury when you went into service. A key issue is, or was your injury noted on your service records? Okay, so if you were examined at the time of your entry into the military service, okay, whatever branch it was, and your condition was not noted, then there is called a presumption of soundness that applies. That's the easier route. That's not part of this video, though. We'll talk about it in another video. However, if your condition was noted at the time of your entrance, then we have a harder road to hoe, okay? Now, Let me give you an example of what happened. Client, when he was young, had a chest issue, and he was operated on when he was a young boy. So he had a nice scar. So then he went into the military. They noted the scar on his chest. I mean, it's plain as day. They ran some tests. I ran him through a series of tests to make sure he was okay. They noted it. They rated him at a 0. Now, he shipped off to the Middle East. He's exposed to burn pits. So whatever this was that was happening with him worsened or was aggravated because of his exposure to burn pits. So we're able to get him qualified for compensation, showing that his condition was aggravated as a result of his exposure to burn pits. So if you've got a condition, a pre-existing condition, all is not lost because you get the presumption of aggravation. So how do you take advantage of this presumption of aggravation? Well, document your increase in your disability in your service treatment, maybe in your service treatment records. That's the best means, okay? But if you don't have that, then you can certainly use your medical records from your private doctors, okay? That's a good way. Again, the best way is to say, I was at a 0 rating here, and I had 100% lung capacity. Now I've got 40% lung capacity because of my exposure. These medical records from your private physician, as well as, lay statements from spouses or other people who have observed you and noticed you and your disability, can be submitted in support of your claim for service connection based on aggravation of a pre-existing condition. Remember the buzzwords? Again, that's where we would need to talk to your doctors. Make sure that they are actually putting in your record what the VA is needing to see, as far as making sure that we've got a connection between your injury and your aggravation and your service. In virtually all aggravation claims, a medical opinion is needed to confirm that your claim condition has increased or was increased during your service. Now, what happens if your injury comes many years after service in the form of a cancer, prostate cancer, some kind of respiratory illness, any kind of other disease, okay? These arose because of your exposure to toxins within the service. Burn pits, contaminated water at Camp Lejeune, all kinds of things. Maybe you were in the service and you were in Vietnam, or you were in Thailand. Maybe you were in some of those areas under the PACT Act that we talked about, burn pits. If you were there, the law provides for the presumption. I mean, you don't have to prove service connection. All you got to do is, of course, you got to prove that you were there, and you can do that through your military records. But I would always suggest that you present medical evidence that say, hey, it is as least likely as not that my condition was caused by my exposure to Agent Orange while I was serving in Vietnam, or respiratory illness while I was in this area with the burn pits. Whatever it may be, I'm a belts and suspenders guy. Let's just give them the medical evidence. Service connection is available for almost any disability that is a result of another service-connected condition. They call it secondary service connection. Now, this is not the same as an increased rating claim. This is a totally separate secondary condition. Basically, this is a disability which is proximately related to your service-connected disability or injury. Remember when I talked about the knee and said, look, you hurt your knee, but because of your hurt right knee, you've overused your left knee, and now you've got problems with your left knee. That's a secondary service connection. Or maybe you have plantar fasciitis, and because of that, and it's very painful, maybe that has caused problems with your hips. Or maybe you have hips that cause your plantar fasciitis. So you have secondary service connections you have a chance to rely on. Again, a lot of those can be handled through these DBQs. Again, never ever underestimate the value of a DBQ. So when your service connection is established for a secondary condition, your secondary condition is considered part of the original condition. So your secondary service connection can be established both where a service-connected condition contributes to the creation of a new disability, remember, right leg and left leg, and where a service-connected disability aggravates right leg, left leg, remember? So if a service-connected condition aggravates a non-service-connected condition, you can be service-connected. That's your connection, that's your nexus, okay? And compensated. They look at your degree and they assign the rating for that, okay? So, look, here comes the secret sauce to all of this, okay? The key to success for secondary service connection, and really the secret sauce for all service-connected disabilities, is medical opinions from a private, not a VA doctor. That's where your DBQ comes in. Don't rely on the VA to do this for you. You will benefit immensely from getting your own private doctor to fill out a DBQ for you to show the connection. Your medical expert should provide you with an opinion as to whether it is probable that your claimed disability was caused or aggravated by your service-connected condition. Hey, look, it'd be great and even more persuasive if your medical expert, beefed this language up and says, hey, it's very likely that your claimed disability was caused or aggravated by your service-connected condition. So, again, the secret sauce to any kind of nexus claim, I think, is always going to be medical evidence, and especially a medical opinion from your doctor, not the VA. Hey folks, thank you for watching. I hope you learned a lot today. We hope we got some questions answered for you and you know how important Nexus is to your claim. Hey, look, go check out this video. Don't file without this form. And we're talking about DBQs. We go in a little bit more in depth in how important that form actually is. We need you to have this form filled out by your private medical doctor so that you can be more successful with your claim.